Good evening and welcome back to The Particulars. Everything you're about to hear was fact-checked and verified as of this afternoon. We are investigators teaching from the public record. Our opinion, our analysis, not legal advice. 11 days after January 24th of 2023, Lindsay Clancy is handcuffed to a hospital bed in the surgical ICU at Brigham and Women's. 2 state troopers outside the door, a nurse in the corner of the room. She cannot move below her sternum, and she asks to call her husband. Tonight, you are going to hear what was said to him from a witness who was physically there in that room, heard it himself, and testified about it under oath today.
We also found something after Monday's show that reframes everything that happened on Tuesday, a court ruling the public hadn't seen. We went back to day 2 transcript, not Reddit, the actual day 2 transcript. We found something. Tupac, days 1 and 2 are in the legal minute. Let's get into the particulars. Quick housekeeping, follow us here on TikTok and subscribe on YouTube so you never miss the replay. Coffee and Sticker Mule are in our link tree if you want to support the show directly.
So first, what we found after we went off air. So one of the things we tell you constantly, our analysis changes when the record changes. So Monday night, we gave you day 14 based on what we had at the time of the show. After the show, I found something else. Before we get into day 15 testimony, we're going back because it changes how Tuesday looks.
On August 17th, the same day as day 14, Judge William Sullivan issued a supplemental decision and order specifically about the 3 late-disclosed defense expert witnesses, Dr. Laposata, Laposata, that's how it's phonetically written out.
It's actually, if you're saying it in like the Boston, it's Laposata.
I'm not from Boston. Dr. Volfovich and Dr. Condie.
Good job.
It supplements the August 7th ruling on whether those witnesses could testify at all. A supplemental decision and order is a written ruling from the judge that adds to or clarifies an earlier order. This one supplements August 7th and was issued August 17th, the same day as day 14.
So the court found no evidence of bad faith by the defense. The delay in disclosing those witnesses was, according to defense counsel, attributable to his own actions as a sole practitioner managing several complex cases simultaneously. The court also found it could not have been a meaningful surprise to the Commonwealth because the testimony directly rebutted positions the prosecution had been advancing about Lindsay's injuries and the alleged suicide attempt. The court noted it has been clear throughout this case that the defense would argue she attempted to commit suicide, evidenced by self-harm and jumping out a window. And this is the sentence from Judge Sullivan's order that I want to put on the record directly because this is the court's own characterization, not ours. So, quote, the Commonwealth's opening statement and evidence elicited during the trial have advanced a position that the defendant's actions soon after the death of her children were not genuine attempts at suicide, end quote.
The order is more specific about what the Commonwealth's position actually was. Sullivan wrote that the Commonwealth implied Lindsay merely sustained superficial lacerations, and that she slid along the wall of her home when exiting, rather than jumping. The defense's rebuttal position, she intended to kill herself through significant self-harm and jumping headfirst out a second-floor window. That is the exact factual dispute Laposata and Volfovich were called to address.
So there's also an important limitation the judge imposed. Laposata and Volfovich were expressly precluded from testifying that Lindsay's actions constituted a, quote, serious and or complex, end quote, suicide attempt. That is a factual issue for the jury to decide. The judge let the testimony in, found it highly material, and simultaneously put a guardrail around the ultimate conclusion the defense wanted those witnesses to deliver.
For Dr. Condie specifically, the court ordered voir dire. First, because Sullivan wanted to determine whether his medication testimony would be cumulative. That voir dire is what you watched at the top of the Condie segment Tuesday. And there is a footnote in the order about Emily Thorndike, a former McLean Hospital employee. The judge said that request would be separately addressed. We will tell you how that resolved later in the show.
So here's why this matters for everything that follows. When you watch Sprague cross-examine Laposata on Tuesday, you are watching a cross-examination that is operating inside boundaries already litigated. So there was an admissibility fight before Laposata ever took the stand. Sprague is working not just against Laposata's opinions, she is working against what the court had already determined was permissible testimony.
And now we will go to our first segment of the show, which is the trial watch. Yes, we talked about the trial already a little bit, but this is something that we wanted to clarify from information that came in between shows, in between Monday and Wednesday. So for our trial watch, obviously we have the Commonwealth versus Clancy, and we are on days 15 and 16 that we're covering?
Yeah, today was 16. So on January 24th of 2023 in Duxbury, Massachusetts, 3 children, 5-year-old Cora, 3-year-old Dawson, and 8-month-old Callan Clancy were killed inside their home. Their mother, Lindsay Clancy, a labor and delivery nurse, was found beneath a second-story window with life-threatening injuries. She survived and is paralyzed from the sternum down.
Clancy is charged with 3 counts of murder, and she has pleaded not guilty. The defense does not dispute that she killed her children. The contested question is criminal responsibility. The defense argues she was suffering from severe postpartum psychosis and was not legally responsible for her actions. The Commonwealth says she acted intentionally.
And before we go further, a content note. Today's testimony includes detailed clinical discussion of suicide injuries, strangulation of children, and postpartum mental illness. If you or someone you know is struggling, the 988 Suicide and Crisis Lifeline is available by call or text 24 hours a day.
Day 15. The defense case continues with 4 witnesses. It continued Tuesday with 4 witnesses. We are taking them in order because the sequence matters. Number 1, Susan Clancy.
Before we talk about what Susan Clancy said, let's talk about who she is, because that context matters for why both the direct and the cross matter.
Susan Clancy is Patrick's mother. She worked as a labor and delivery nurse for 38 years at South Shore Hospital, the same system as the perinatal behavioral health program Lindsay was referred to. She is the grandmother of Cora, Dawson, and Callan, and she testified for the defense.
So here's why the defense called her specifically. Susan can speak to what Lindsay was communicating to her in real time in the fall and winter of 2022. She could also describe what she personally did in response. So she reached out to colleagues and to nurse practitioner Julie Paul, using her own professional connections to try to get Lindsay help. She is not just a family witness offering sympathy. She is a 38-year nursing professional who watched this unfold and tried to use her network to intervene.
On direct, Susan described Lindsay reaching out in fall of 2022, saying she felt unwell. Insomnia, loss of appetite, anxiety, sadness. She said Lindsay was, in her own words, begging for help. Susan reached out to the perinatal clinic and to Julie Paul with Lindsay's permission. She was present on November 16th when Lindsay went to the South Shore ER. Susan was working that day and came down to sit with her. A binder of text communications between Lindsay and Susan was admitted into evidence over Commonwealth's objection.
The Commonwealth's cross covered the limits of what Susan actually knew firsthand. Most of what she understood about Lindsay's treatment came from what Lindsay and Patrick told her, not from records she reviewed personally. She acknowledged she was not in Lindsay's appointments and was not aware of everything Lindsay said to her providers.
Now, the mortal sin moment. During cross, ADA Buckingham asked Susan, an active Catholic, whether murder is a moral sin. The judge called a sidebar immediately. When the judge returned, Judge Sullivan instructed them not to consider that question for any purpose.
We're not going to speculate about what Buckingham was trying to establish with that question. Whatever the purpose was, the jury does not get to use it. Sullivan struck it and instructing them accordingly. The cross also covered the civil lawsuit reference, the Aruba vacation, what Lindsay reportedly told her therapist about her in-laws, Watching that cross, the analytical question I kept returning to is the same one I always ask: where does this go in closing?
Now, witness for the defense number 6, Dr. Donald Condie is a child, adolescent, and adult psychologist specializing in psychopharmacology, the study of how medications affect mental health. He has been practicing since 1983. He did not personally evaluate or examine Lindsay Clancy. His opinions are based entirely on record review. And as we know now from Sullivan's order, the court required a voir dire before authorizing his testimony to determine whether his medications options would be cumulative.
So on direct, Condie described Dr. Tuff's notes as sparse, mostly checkboxes, limited narrative description. Neither Dr. Tuff's nor nurse practitioner Gelada ordered blood testing, and Condie testified that blood testing would have been appropriate. He described what he characterized as activation syndrome from the Zoloft increase: insomnia, feeling numb, feeling worse. He discussed fear of symptom disclosure, concern that reporting the worst symptoms could cost Lindsay her nursing license or her children.
Buckingham's most effective cross exchange was clean. Quote, "You didn't interview the defendant, did you?" End quote. He said no. "So you don't know what she was concerned about, you're speculating." He said yes. She also established his affidavit was prepared for the civil lawsuit, that it cites a New Yorker article as a factual source, that he spoke with Patrick Clancy for 90 minutes but did not document that conversation in the affidavit. And she pressed the Zoloft pill count: 30 filled, 7 missing when the bottle was inventoried months later. So our read as analysts, the distinction worth holding here is between attacking the substance of Condie's pharmacology opinions and attacking the foundation he used to reach them. Those are not the same thing. The pill count does not make activation syndrome stop existing as a pharmacological phenomenon. What Buckingham did effectively was give the jury reasons to weigh those opinions differently. Whether that undermines the opinions themselves is for the jury.
So the next witness was Dr. Elizabeth Laposata.
And this is where, because of Sullivan's order, we have context the audience would not have had just from watching the live stream, because we talked about that in the beginning.
Correct. So Dr. Elizabeth Laposata is a board-certified forensic pathologist practicing since 1983 and a former head of the Rhode Island Office of Chief Medical Examiner. She testified by Zoom. She reviewed approximately 500 crime scene photographs, police reports, the medical examiner files, the EMS reports, and hospital records for Lindsay and all 3 children. She did not treat or personally examine Lindsay. So before her testimony, there was already an admissibility fight. The court ruled she could testify about Lindsay's wounds and injuries, the mechanism of the spinal injuries, the lack of evidence of inflicted injuries unrelated to the children's deaths, and the time required for loss of consciousness from jugular vein compression. What she was expressly precluded from saying that Lindsay's actions constituted a serious or complex suicide attempt. That is for the jury. The guardrails were set before she took the stand.
On direct, she testified about Lindsay's wrist and neck injuries, sharp force wounds, multiple hesitation marks on the wrist, which she called a classic finding in suicide attempts. She walked the jury through the fall mechanics: headfirst exit from a second-story window, impact transferring force down the spine, C1 burst fracture, thoracic fractures, spinal cord damage. The brain staying intact while the vertebrae absorb the force is the expected mechanism in that type of fall. She also testified that Laposata's opinion was that a resistance band wrapped multiple times around the neck produces immediate vessel compression, consistent with loss of consciousness within seconds.
So I'm going to separate something for you, okay? Because this is my observation. We've already talked about this, that I've watched the full daily trial as it has unfolded. Okay, so I want to separate the record from something I observed watching myself personally, because I think it belongs here. So during Sprague's cross of Laposata, Sprague looked increasingly frustrated, so more visibly so than I've ever seen her during the crosses of other defense experts, particularly when Laposata kept trying to explain or qualify her answers beyond the yes or no framing that Sprague was pressing for. I wrote it down in my notes while it was happening, and that is my read of what I watched on the live stream. You may watch the same cross and read her differently. However, I'm putting it on the table as an observation, labeled as exactly that.
The cross opened with the Rhode Island Medical Examiner's Office violations during Laposata's tenure. Laposata said the unsafe condition was a light bulb out in a hallway 20 years ago. Sprague then challenged the fall mechanics, pressing that Lindsay had no skull fracture, no brain bleed, no visible exterior head injuries from a 13-foot head-first fall onto frozen ground. She said frozen ground 100 times. Laposata consistently held forces transmitted to C1 is the expected mechanism. Sprague moved the hospital head photographs into evidence. The jury now has them.
The record check, day 2 versus day 15. So this is where my ears perked up. During cross, Sprague asked Laposata about the exercise bands, and I remembered Patrick saying something about untying that band.
So we went back.
Not Reddit, not someone else's recap. I pulled the day 2 transcript and my day 2 notes from my computer.
Here's what Sprague said to Dr. Laposata on day 15. We are reading it from the transcript. Quote, "There's been no testimony, no evidence, noting, nothing, showing that they were knotted and left there, correct?" End quote. And Dr. Laposata agreed. They weren't tied in a knot and left around the children's neck, according to any of the evidence.
Here is where the day 2 transcript comes into play. Patrick Clancy on the stand. Sprague conducting the direct examination herself. He is asked how he got the band off Cora's neck. He says, quote, "I think I untied it," end quote. Sprague follows up and asks whether it was a knot he had to put everything down to deal with, or how was it tied. Patrick says he is not sure he fully remembers. Then Sprague asks, and this is still Sprague on her own direct, quote, "Do you recall describing it previously as when you initially tie your shoes but then don't do the bow?" End quote. Patrick, quote, "Yeah, that sounds right," end quote. Our read, as analysis, Sprague's day 15 question was specifically about the bands being knotted and left there, technically different from tied in any way. Patrick removed the bands. What he described was the first stage of tying a shoe, a single cross, not a completed bow or a fixed knot. So these two statements are in tension, not in flat contradiction, but the word Patrick used was untied, and the person who established a shoe tying description on the record was Sprague herself on her own direct examination 2 weeks earlier.
We doing show and tell?
You want to?
Yeah. The band demonstration. At the end of that cross exchange, Sprague physically handled the exercise band in the courtroom. Laposata said on the record, the band just fell apart. It didn't stay in a circle when released. Sprague used that as her closing image. It was left there. It fell apart. Our read, as analysis, Laposata's direct testimony was that what mattered was the wrapping while the band was applied. Laposata's opinion was that while applied, the compression was there regardless of what happened when the band was released afterward. A band that falls open when you let go of it was still, while wrapped, producing the compression Laposata described. She agreed that the factual premise and then told the jury it didn't change her opinion.
Okay, and now what I'm going to do is I'm going to step away from the script for 2 seconds, because this encounter during this, so that day specifically in regard to it, it was a Zoom and she was supposed to, have her testimony at a certain time, and they were having technical difficulties with getting the Zoom set up, so they had to go to recess, and then they came back and they said, we still can't get it, so they went and skipped her and came back later. Then we get up here and we're having cross with Sprague, who is, you could just tell she was getting kind of worked up because of the line of questioning. So then when she says, nope, I think she had them on, but you can take them off for the purposes of, so anyways, so then she steps back out of the frame of the live stream, and she then goes to her table, and you can hear the rustling of the evidence bag. So she gets the evidence bag, she puts her gloves on, and then after she puts her gloves on, she takes the band out and she goes over to the table, and she then proceeds.
We'll use my leg.
No, she didn't put it on a leg.
Yeah,
she literally takes the band like this, and she goes, so you're telling me it was like this with this type of band, and when I put it on the table, it falls apart, so it doesn't leave the pressure. However, what we were trying to get across with the doctor and her testimony is she was saying that, yes, they do fall apart it's a nice leg. So if you have them as they are, they would fall apart, yes. However, if there was some kind of looping type, it would stay. But the demonstration didn't show that part. But that was what the doctor was trying to get across when she was speaking, but she was not able to.
Why? Because the Commonwealth is the reason I got banned on TikTok.
I don't know why she was, well, I do know why, but I'm not going to say that. But again, the difference is, which then she went in and she brought in the fact that, she tried to, from the beginning, kind of say that, the testimony, you were in this area that, you got violations, trying to, so to speak, discredit the expert witness to the jury, so to speak. And then again, this is all my opinion, my analysis. However, as someone who watched it, when she keeps bringing up all of these things, and she then goes over, she's like, well, you testified in this case saying something completely different. That's where then you could tell that Sprague was starting to get, as my read on her watching it, it was like she was getting frustrated again when she was kind of putting the gloves on, all of the things. And I think that kind of played out differently than what she thought it was going to play out as.
The fourth witness.
Now we'll go on to the next witness, which was Dr. Paul Zeisel. So Dr. Paul Zeisel is a clinical and forensic psychologist, not a psychiatrist. He does not prescribe medication. He has extensive experience with military evaluations, combat trauma, and governmental agencies. Of the defense expert witnesses we've heard from so far, Zeisel has had by far the most direct clinical contact with Lindsay Clancy, more than 65 visits as of his testimony.
On day 15, Zeisel testified about the MMPI, the Minnesota Multiphasic Personality Inventory, which includes scales designed to detect whether someone is faking or exaggerating symptoms. The government's own evaluators administered this test to Lindsay. Zeisel was asked his opinion on the results. Quote, she is not faking. There was no evidence of any malingering. She presented as an honest citizen. End quote.
Day 15 ended during Zeisel's direct. On day 16, he completed it. By December 2nd of 2022, a South Shore perinatal clinic visit, Lindsay was expressing fear that people could hear her thoughts. Her specific concern was that if people could hear what she was thinking, her children would be removed from her care. That is thought broadcasting, so it's a recognized symptom of psychosis. This came through Zeisel's direct testimony, describing what his evaluation and the record showed. It is qualitatively different from the anxiety, insomnia, and depression we have heard about throughout this trial.
And by January, Zeisel testified Lindsay was having intrusive thoughts continuously, voices in her head, heard constantly, getting worse, telling her to kill herself. On January 24th, the day of the event, she took Cora to a standing pediatrician's appointment, built a snowman with the kids, ordered food. Zeisel testified that even in a psychotic state, someone can still go about routine daily activities. Then Reddington asked Zeisel to state his professional opinion against the exact Massachusetts legal standard for criminal responsibility.
Quote, she was unable to conform her behaviors to the rule of law and she had no appreciation for the wrongfulness of her act, end quote.
And that moves us on to the phone call.
Yes.
February 6th.
So here's the context. Reddington contacted Zeisel on February 3rd of 2023, 10 days after the incident. February 4th, Zeisel went to Brigham and Women's. He was initially told he could not see Lindsay. Reddington made a call. By 12:30 that afternoon, Zeisel was in the room. Lindsay was handcuffed to the bed with hard handcuffs in the surgical ICU attached to monitoring equipment, unable to move below the sternum. 2 state troopers outside the door, a nurse in the corner of the room.
She didn't know exactly where she was. She wasn't sure of the time. She knew who she was. She said she remembered what happened, but it was fuzzy. She asked about Patrick. They left a voicemail on February 4th. 2 days later, February 6th, he called back.
Here's what Zeisel testified she said to Patrick on speakerphone in his presence while handcuffed to that bed. She told him she loved him, and she told him that she had heard a male voice ordering her, telling her that she had no choice but to kill the children. Reddington asked whether Zeisel told her to say those things. He said no. He was asked why he let her call her husband at all, and Zeisel's answer, quote, I let her call her husband out of human compassion, end quote.
And I want to stop right there because that timing matters, but so does the context. Reddington was already involved. Zeisel was in that room because Reddington contacted him. So we're not going to tell you what this statement means. What we are going to do is put the circumstances on the table, because what matters for this trial is when, according to Zeisel, Lindsay first described a male voice giving her orders. That is February 6th, 2023, 11 days after the deaths. The Commonwealth is going to have questions about all of that.
So the Zeisel cross and what followed.
Buckingham opened by attacking Zeisel's independence. He has worked as an independent contractor for the Commonwealth cases. He is friends with Reddington. The ABA's ethical standards for forensic evaluators were put on the table. She played a December 2023 news conference he gave about this case. Then she pressed him on calling Lindsay, quote, my patient. In a letter he wrote to the court asking that Lindsay not be chained to the van during trial.
Meaning in like
going to and from.
To and from.
Yeah.
Yes, correct.
That nurses be available because of her paralysis.
So Zeisel's response when Buckingham pressed, quote, but you call her my patient in the letter, end quote. And then, quote, I wrote the letter. Whose patient would I be referring to if I'm speaking about Miss Clancy, given that she's my patient, end quote. That was one of the more memorable exchanges of that cross because they made quite a bit of, deal about that there. So the voice distinction, the most important part of cross.
Buckingham established that in the medical records, across all of Lindsay's provider visits between September and January, Lindsay never told any of her providers she heard a voice telling her to kill herself or her children. Not in the records. Zeisel confirmed that.
But she asked who Lindsay did tell, and Zeisel's answer brought a name in we hadn't heard. So, Chaplain Sheila Kavanaugh at Brigham and Women's Hospital. Zeisel testified that Lindsay told her, which this was what was confusing about this part, is it was a lot of told her she heard a male voice instructing her to first kill her children. So it was I heard. So Zeisel was saying that he was told by this person that was told by Lindsay. So it was like 3 removed from, it was the telephone game again.
And then Buckingham established a distinction. She said, quote, fair to say the only time she specifically said she heard a male voice was when she recounts the events on January 24th of 2023, end quote, and Zeisel responded, that's correct.
So here's what the record shows after today. Two separate phenomena were clarified. First, ongoing persecutory intrusive thoughts, voices so loud she believed others could hear them, which is thought broadcasting, present across the fall and winter of 2022. Second, the specific male voice ordering her on January 24th. That is what she described and Zeisel was directly speaking about. So those are distinct and we want to present them precisely.
Anyways,
I don't even know the context.
My Tragedy and the Wish Vase. Buckingham also surfaced how Lindsay refers to January 24th, asking Zeisel whether Lindsay refers to the situation as, quote, my tragedy. Zeisel's response, quote, that moniker of my tragedy, that's just one of the things that she'll say, end quote.
Meaning she refers to it as different. Like it's not always my tragedy, but when she talks about that specific event, that was one of the phrases that she would say. Oh, that was my tragedy. So on redirect, Reddington introduced Exhibit 285, a wish vase. Some people may or may not have remembered that from the beginning. Over Commonwealth objection, the judge admitted it. A wish vase purchased in Hawaii on Lindsay and Patrick's honeymoon. That is now in evidence. The jury has it.
And Reddington made sure the jury heard two more things before Zeisel was excused. Lindsay speaks about her children. According to Zeisel, she really loved them. She misses them. She thinks of them every single day, almost every moment of the day, and her current status at Tewksbury, she is on a one-to-one. One staff member monitoring her at all times to prevent her from taking her own life. In Zeisel's words, quote, there's always a concern that sits directly below the surface, end quote.
We did then get a chance to see the Emily Thorndike voir dire and the ruling on it. So that is where we're going next. So after Zeisel was excused, the jury went out and the court held a voir dire for a potential defense witness named Emily Thorndike. Thorndike is a licensed clinical social worker who now runs a private practice in Brooklyn. Before that, she worked at McLean Hospital for approximately 7 years in the short-term unit, the same unit where Lindsay was admitted in late December.
She had been watching this trial. She got into trial watching during the Karen Reed case via TikTok. At some point, she posted about what she saw, and apparently that is how the defense found her. When she became a potential witness, she was sequestered from the broadcast. The news headline today said, quote, judge blocks witness defense, found after TikTok post, end quote. That is Emily Thorndike.
What she would have testified to, the individual therapy was not available on that unit, so contradicting what the prosecution's McLean testimony implied. Weekends and holidays, only one doctor on duty. Staffing level, 4 mental health specialists and 4 nurses. That does not change as census fluctuates. Reddington argued, quote, I'm not bringing her in to try to disparage McLean. They're doing a good job of that themselves. I'm bringing her in as evidence as to what Patrick's testimony was, as to corroborate with him, end quote.
Sullivan applied the same Chappie-Durning framework he used for the other late disclosed witnesses. He found Thorndike credible, no bad faith. Commonwealth had been aware of her for over a week, but on materiality, the factor that sank her, Sullivan found limited materiality. She hadn't worked at McLean in approximately a year. Gap in time, limited value, ruling, Thorndike will not testify. However, the McLean records documenting holiday staffing levels and programs available will be admitted into evidence. After the Thorndike ruling, Judge Sullivan adjourned the court early, before the jury came back in saying, quote, due to unforeseen circumstances, we are going to recess until tomorrow morning. You are not to speculate, end quote. Court resumes Thursday, tomorrow at 9 a.m.
The reason for the unforeseen circumstance was not stated on the record in the courtroom broadcast. If you have seen social media theories about what it was, we do not have a docket-confirmed reason. That is a flag for after the show, not a claim we make tonight. So, A few things that I threw in because why not? I just thought it would be fun. Things that Lacey caught. So, a few things I want to put on the table from watching this week that are not going to be in any headline you read tomorrow morning, and I'm telling you up front, these are my live reads from watching the stream. They are observation, not established facts. Okay, so first, Sprague during the Laposata cross. I already mentioned she looked frustrated. I want to add the specific moment. When Sprague was handling the evidence bag, putting on the gloves, pulling out the exercise band, that entire sequence had a visible energy to it that stood out to me. And when the demonstration ended with the band falling apart and Laposata basically said, "That's correct, and here's why it doesn't matter to me," that did not look like the cross landing the way it was intended. That's my read. Watch it, form your own.
What else?
So second, Lindsay at the defense table during Zeisel's cross. While Buckingham was reading through the Tewksbury anniversary records, Lindsay wrote something on a legal pad and showed it to Reddington. They both smiled. In 3 weeks of watching this trial, that was the first time I saw that from her in the courtroom. And I'm not going to tell you what it means because I don't know. However, I am telling you I saw it and I made a note in my notebook. Okay? And third, Buckingham argued with Zeisel about whether Beachbody is an MLM or a legitimate business. The judge told her to let him finish. Zeisel answered, "If you participate in something for marketing purposes and lose money, that is one definition of a scam." He did not move. I genuinely cannot explain the strategic calculation there. However, it was one where I literally was sitting there watching and I'm like, are you serious that we are bringing Beachbody into a murder trial? Tonight's evidence of the night is about a method, not a piece of physical evidence, and not a retread of the record check we just showed you in Trial Watch. So I want to use what we did this week as an example of a larger process, because if you follow trials, this is a skill you can actually use.
Here's the situation. 3 weeks into a complex trial, a statement made in week 1 that is still technically in evidence in week 3, a lawyer in week 3 characterizing what that week 1 record shows. The question, is that characterization accurate?
So step 1, identify the specific claim. Sprague told Laposata there had been, quote, no testimony, no evidence, nothing, end quote, about the bands being knotted and left there. That is a claim about a specific portion of a specific record.
Step 2, go to the source, not a recap, not someone else's summary. We pulled the actual day 2 transcript, searched it, found the specific exchange, and time-stamped it.
Step 3, read the actual words in context, not just the part that supports or contradicts the claim, all of it. So Patrick said, quote, "I think I untied it," end quote. Sprague asked a follow-up. Patrick said he didn't fully remember. Sprague then reminded him of his prior description. Patrick confirmed all of that context matters.
In step 4, compare carefully. Is the day 15 characterization a flat contradiction of the day 2 record? A narrower framing? An accurate description of part of the record that omits another part? In this case, tension, not flat contradiction. And that distinction matters for how you present it.
So step 5, ask what it means, not what it proves. So what it means is that two things sit next to each other in the same trial record and look different when you put them side by side. That is enough to present to your audience. You do not need to tell them what to conclude.
The reason this process works is that the record is available. YouTube, time-stamped, searchable. That is not a small thing. In most trials in human history, the public never had access to this. We do. And the way to honor that is to actually use it, rather than outsourcing the analysis to someone else's headline.
But without further ado, we will now move on to...
We're getting away from the Lindsay Clancy for a bit.
A hot minute. We're going to go into a hot legal minute. And this is, my friends, the Keefe D. Davis Tupac trial. So we are in Las Vegas, days 1 and 2 of the trial of Dwayne Keefe D. Davis. So quick catch up for anyone who missed Monday. Davis is accused of orchestrating the retaliation after Orlando Anderson was beaten at the MGM Grand in September of 1996. The prosecution says Davis's own statements across decades, a 2008 federal proffer, a BET documentary, a published book, are the spine of its case. The defense says those statements are uncorroborated, the 30-year investigation has significant gaps, and no eyewitness ever identified Davis in a photo lineup. That's where we left it Monday.
Day 2 moved quickly. Cause of death is now formally on the record. Dr. Lisa Gavin, a medical examiner, testified about Tupac Shakur's autopsy. Cause of death, gunshot wound to the chest and abdomen. Manner of death, homicide. She also documented prior bullet wounds predating the shooting. Suge Knight's medical records from that same night were admitted. He was also wounded in the shooting.
The MGM Grand fight was established through multiple witnesses and surveillance footage. An MGM security witness walked the jury through what the cameras captured. Orlando Anderson being confronted and beaten before the entourage left for the Club 662. And a detail that surfaced today, at some point after the incident, Suge Knight's side arranged a settlement with Anderson, including Anderson testifying at Suge's probation violation hearing that Suge was just trying to stop the fight, not participate. That settlement is now on the record.
A Las Vegas Metro Gang unit detective testified about the night of the shooting. His unit received a code red at 11:17 p.m. He was at the scene within minutes. Cartridge casings at the scene were consistent with a Glock 40 caliber. What the prosecution claims Davis obtained and handed off. He got a radio update. Light-colored Cadillac, last seen northbound on Audrey Lane. He and his partner searched gang areas. Second update, black males, southbound on Cobalt. They searched, they never found a vehicle.
A cold case detective also testified about how Metro built the case across 30 years. The methodology of cold cases, field interview cards, what it takes to bring one back. The center of this case, Davis's own words, the 2008 proffer, has not yet been put before this jury. That is still coming. Day 3 is tomorrow. So our read as analysis, the prosecution is building the record from the ground up. Cause of death, the triggering event, the immediate police report, the investigation's 30-year arc. When Davis's own statements finally arrive before this jury, that will be the center of this trial. Red flag, which for this, the particular series, it is number 9. A lawyer's question is not evidence. So here is tonight's red flag, and it comes directly out of what we watched this week, but it teaches something different from the record check we already covered.
When you watch a cross-examination, you are watching a lawyer ask questions.
So they can assert things. A lawyer can say, isn't it true that X?
And that blank is not testimony. It is a question. The witness's answer is testimony. The question itself is not evidence. It's the answer.
So why does this matter? Because when viewers watch cross-examination, it's very natural to absorb the premise of the question as if it has been established. If a witness agrees, that goes into evidence. If a witness disagrees, disqualifies, or corrects the premise, what goes into evidence is that disagreement, qualification, or correction. So, a premise embedded in a cross-examination question does not become evidence merely because the lawyer stated it. What becomes evidence is the witness's answer, so including any correction of the premise the witness offers. This is why trial lawyers say the question is not evidence, and why jurors are often instructed to evaluate the answers, not the questions.
Watch what Laposata did throughout her cross. She didn't fight the questions. She answered them. And then she kept adding context. Quote, correct, but the more important thing is, until Sprague cut her off. Each time, Laposata qualified her answer. She was putting her correction of the premise on the record. The jury heard both, the premise in the question and Laposata's response to it.
So this is my opinion, the media literacy takeaway. When you see cross-examination and hear a lawyer assert something in a question, note whether the witness accepted it, corrected it, or qualified it. Because those are the 3 very different outcomes that can look identical on a surface recap. So, quote, Sprague asked whether the bands were knotted and Laposata said correct is a very different from, quote, Sprague asked whether the bands were knotted. Laposata agreed, but then added that the configuration after removal didn't change her opinion about what happened while they were applied. And I will say, watching this week, Laposata was very good at the second of those.
That's where the particulars stand tonight. If this is your first time here, we teach from the public record. We tell you what's confirmed and what isn't. We never pretend a headline is a fact.
Day 16 wrapped early due to unforeseen circumstances. Zeisel is excused. Emily Thorndike will not testify. But the McLean staffing records are in. The defense case continues Thursday. Zeisel placed a specific external male voice on the evidentiary record, described specifically about January 24th. The Commonwealth said during the Rule 25 argument that it anticipates rebuttal witnesses. When the defense rests, this trial takes its next turn. We will be here. Follow us on TikTok, subscribe on YouTube, both so you never miss an episode. Coffee and Sticker Mule are in the link tree if you want to support the show directly. And because tonight's episode included testimony about suicide, self-harm, and the deaths of children, we want to leave this here again. The 988 Suicide and Crisis Lifeline is available by call or text anytime. Our opinion.
Our analysis.
Not legal advice. Headlines end. The details begin. We'll see you Friday night at 9. Thank you, everybody. Have a great night.